As presented by Henry County TV and sponsored by the Henry County Community Development Block Grant Program, the U.S. Department of Housing and Urban Development, and Metro Fair Housing Services, Inc., the following is a video presentation by Ms. Elizabeth Main. Elizabeth is a staff attorney with the Eviction Prevention Project of the Georgia Legal Services Program. The agency's mission is to provide free civil legal services to 154 Georgia counties, including Carroll, Coweta, Fayette, Henry, Newton, Paulding, Rockdale, and Spalding. The Eviction Prevention Project represents tenants in eviction cases and in cases against landlords for issues such as security deposit recovery, non-repair, and illegal lockouts and utility terminations. This video is being made available in an effort to affirmatively further fair housing and provide Henry County residents with current information relating to their rights under the fair housing laws.
I'm Elizabeth Main. I'm a staff attorney with the Georgia Legal Services Program, and I work in our Eviction Prevention Project. I'm going to be talking today about the CDC order that was issued to deal with evictions for non-payment of rent. I want to start off by saying that the information I'm presenting is current as of May 11th, 2021. I want to make that clear because this is a situation that's changing rapidly. So to start off, the CDC's order halts most evictions that are based on non-payment of rent. It does not apply to evictions that are for other reasons, such as a lease violation, any other grounds than non-payment of rent. Those evictions can still go through the court. At the moment, the CDC order is stopping non-payment evictions until June 30th, 2021. The CDC took this action to basically help prevent the spread of coronavirus by ensuring people are able to practice social distancing and comply with stay-at-home orders. The CDC did not do this specifically to, help renters who are experiencing financial difficulties. That wasn't the goal of the order. The goal was basically to stop the spread of coronavirus. And I want to, before I go into a little more in depth of what is in the CDC order, I want to make it clear that there is currently a legal challenge to the CDC order that's working its way through the courts. Several landlords and realtors have filed suit to challenge the legality of the CDC order. They're basically alleging that the CDC had overreached its authority, which it gets from the Public Health Service Act. Recently, the DC District Court did rule on May 5th that the CDC did overreach its authority in that way. However, that decision is being appealed, and there is a temporary stay in place. So at the time that I'm giving this presentation, the CDC order is still in effect, and tenants should still seek its protections because we are not 100% sure if it's going to be struck down or if it's going to continue through June 30th. So the CDC order, essentially the protections that it offers to tenants are it prohibits a landlord from enforcing an eviction order by having a tenant removed from rental property for non-payment of rent before July 1st. It also prohibits a landlord from harassing or intimidating a tenant to vacate. This means that it prohibits a landlord from, for example, repeatedly calling a tenant, multiple times a day, repeatedly going to the tenant's house and banging on the door at all hours, that sort of thing. It doesn't necessarily prohibit a landlord from asking a tenant in a reasonable way, in a reasonable method, to pay their rent, or even from asking them to pay their rent or move out. It merely prohibits harassing or intimidating behavior. It also doesn't prohibit landlords from filing for eviction in the courts, merely that they cannot, once they get an eviction order, have that enforced by actually removing a tenant. Some courts are still issuing eviction orders. Some courts are issuing stays, meaning that eviction cases are not proceeding. Once the landlord has filed them, they're on hold until the CDC order expires. What a tenant might experience from the courts is going to vary depending county by county, depending on what county the tenant is living in. So what housing is covered by the CDC order? It covers tenants living in any rented housing, including government subsidized housing. This includes houses, apartment units, mobile homes, land and mobile home parks. It does not protect you if you live in a hotel or a motel or other kind of guest house situation. The exception for this is some extended stay situations. There have been 1 or 2 courts in Georgia who've held that where someone is staying in a mobile home for an extended period of time as their primary residence, they should be considered a tenant and they should be given these protections under the CDC order. But again, that will depend on what county the tenant is living in and what the court's position on this is in that county. It does not protect you if you're a homeowner that was foreclosed upon and you're now being evicted. It's solely for renters. The next question is, are tenants automatically protected? No, tenants are not automatically protected. Just because the CDC order is in effect, don't assume that you don't need to do anything if an eviction case is filed against you, or you don't need to do anything if your landlord says they're going to file an eviction. To be protected from eviction under the CDC order, a tenant must complete and sign a document called the CDC Declaration and deliver it to their landlord. This must happen before any protection is given. It's also important that tenants do not change the words in the declaration. For example, a landlord gives a tenant a copy and says, this is the CDC Declaration, you must sign it, and it includes statements that don't match what we're about to go over of the statements that are in the CDC Declaration. Tenants do not need to sign that if it includes extra things, if it includes extra requirements about the tenant providing financial information to their landlord. You only need to sign the declaration that we're about to go through. The declaration must be given to a tenant's landlord, the owner of the property where the tenant lives, or the property manager. This is before you can get any protection, you have to give it to your landlord. Every adult listed on the lease must sign and complete a declaration and give it to the landlord. If there isn't a lease and you're just living in the house and paying rent each month with nothing in writing, just have every adult who's living in the household sign the declaration and give it to the landlord. Be sure to keep proof that you provided the declaration to your landlord and keep a copy of the declaration for yourself. This is just in case there is a court case or some other kind of action and you want to have proof that you did give the declaration to your landlord. And you can give it in the form of a text message, taking a photo of the declaration, sending it by text, sending a copy by email, obviously by mail, registered mail. Any of those methods are fine. All right, so just to go through the declaration, it's a document the tenant must complete and sign, obviously. I've included a link here to one copy of the declaration form. You can also, sometimes the CDC will put out an updated version, so you can also just Google the CDC Evictions Order Declaration, look for a link to the CDC's website, cdc.gov, and get it from their website directly that way. It's important that you read the declaration and understand it. I want to make it clear that by signing the declaration, you are basically swearing that every statement in it is true. If you make a false or misleading statement or an omission, that is considered to be a criminal act like perjury. It's a sworn statement, so you could be prosecuted, you could go to jail or fined for doing that. So be absolutely sure that you understand what's in it and that it is true for your situation before you sign it. All right, in this next slide, I've just put the full version of the CDC Declaration just so you can briefly understand what it should look like. Obviously, if you're looking at if later on you get a document and it doesn't look like this, you might want to verify that you have the correct declaration. So briefly to go through the statements in the declaration. First, it asks the tenant to certify under penalty of perjury, again, that one of the following is true and correct. There are 2 categories here for qualification under income. You have to have one statement that's true for column A and one statement that's true for column B. Column A states you have to either have received a stimulus check, or you are not required to report any income in 2020, or in 2020 or 2021 you earned or expect to earn less than $99,000 as an individual or less than $198,000 if you're a joint filer for taxes. If you get any kind of benefits such as SNAP, TANF, if you're on disability, if you get SSI, if you get any of those things, you're very likely to qualify under this category. But you just need to make sure that at least one of those boxes is true, and then you can check that off. In column B, you also have to have at least one box that's true in column B for the CDC order to apply to you. Column B says you cannot pay your full rent or make a full housing payment because either your housing income has gone down drastically or you've been laid off of work, your work hours have been cut, or your wages have been cut, or you have extraordinary out-of-pocket medical expenses. And by extraordinary out-of-pocket medical expenses, they mean expenses that are 7.5% or greater of your yearly income. So just to be clear, one of each of those has to be checked. Next statement that has to be true, you have to certify, again, penalty of perjury, that you have done your best to make timely partial payments that are close as possible to the full payments that you owe your landlord, and that you've tried to get government assistance in making any rent or housing payments. So both of those have to be true. You do need to try to make partial payments as much as you can pay once you've paid all your other necessary expenses, for example, your groceries, phone bill, electricity, utilities. Once those are paid, you have to pay as much as you can to your landlord with any excess income there might be. If you try to pay that to the landlord and the landlord refuses it, that's fine. If your landlord takes the money but says, I think you could pay more, that doesn't matter. You just have to do a good faith payment of as much as you can. And next, you have to have tried to get help to pay your rent by contacting and filing applications with any of various agencies that can provide money to help pay rent using state or federal money. There was recently a large grant of money issued to Henry County for rental assistance, and that is something that you can apply for. Since Henry County has their own method, you cannot apply using the georgiarentalassistance.ga.gov website. That is not available in Henry County, though it is for many of the other counties outside the metro Atlanta area. Since Henry County got their own grant, you would have to apply directly through Henry County for that. But they do have money for that, so I encourage everyone who's experiencing trouble paying rent to apply. And just keep a record of the organizations that you contact, the date and what the response was. And on the same token, if you try to make a partial rent payment, I would do it in some method that is traceable. For example, through a bank account, through a money order, some way that there's a paper trail of what you paid. And that's good advice for any tenant. Do not make rent payments in cash because they aren't traceable. Even if your landlord refuses to get you a receipt, that can be very hard sometimes later on to prove what payments you actually did make, especially if there's a disagreement with your landlord and your landlord begins to say, no, this person hasn't paid me for months. You need a way to be able to prove what you paid. So, and as a general rule for tenants as well, never pay just using cash. Next statement in the CDC Declaration, if I were evicted, I have no other available housing options, so I would probably become homeless or have to move into a homeless shelter or have to move in with others who live in close quarters. In this case, available housing means decent and affordable housing that's presently available to the tenant. It doesn't mean that a tenant needs to be willing to accept any kind of housing in any kind of condition, irrespective of price, as an alternative to becoming homeless. That means that a tenant does not need to be willing to sign a lease that with a rent amount that they are unable to afford to pay. It also means that a tenant does not need to accept housing that's in kind of an unlivable condition, or it is in poor condition. No electricity, the water isn't running, water's leaking somewhere. Does not mean that you have to accept that. Having to move in with others who live in close quarters, if you have to move in with relatives or you would have to move into, for example, like a hotel, that would be included under this statement. So if any of those are true, you can check that off. You can turn in the CDC Declaration. The next statement is that a tenant understands that after they sign, they need to understand that unless they come to an agreement with their landlord, a tenant is still responsible for rent, back rent, and any fees, penalties, or interest under your lease or under any agreement that you and your landlord came to before you moved in. So, example, if you don't have a lease, if you and your landlord had agreed that if you paid rent late, you would pay like a $50 late fee, that can still apply. If your lease says you must pay certain amounts, those would still apply. Tenant must also understand that they still need to follow the conditions of their lease. Again, evictions evictions are still going through for reasons other than non-payment of rent. If there's some lease violation that's unrelated, if, for example, a tenant's lease expires and there's nothing in the lease that says that it would automatically extend as a month-to-month tenancy, in those situations, a landlord may still be able to file for eviction. And then last statement, unless I come to an agreement with my landlord, if the tenant fails to make the required payments, they could be evicted when the temporary halt of evictions ends. So essentially, once the CDC order ends, either on June 30th or possibly sooner, if the court does rule that it is going to be struck down, then the tenants, all of the rent that the tenant owes would have become immediately due. So what that means under Georgia law is that a landlord merely needs to give a tenant notice that they want the tenant to either pay rent or move out of the property, and the tenant must then pay rent or move out within, and that there is no specific time period. Some states say that tenants must be given 30 days notice or 2 weeks notice. Georgia does not have that requirement. If a landlord would say even that a tenant needs to pay rent or quit in a couple of days, because rent is late, then the tenant must either pay rent or quit, and if the tenant does not leave the property in that amount of time, the landlord could then file for eviction. And I want to be clear also that if the only reason for non-payment was, for example, that the tenant lost their job or there have been medical bills, under the CDC order there is protection. Under Georgia law, without the CDC order, there is no protection, meaning that the judge would still be required, even if they're sympathetic to the tenant's situation, the judge would still be required to issue an eviction order, and under Georgia law, the maximum the tenant could be given to move is 7 days. That's actually written out in the statute. The judge cannot give you more than 7 days. So just to be clear, once the CDC order is expired, it will be a tight, time-sensitive situation for tenants to be in. So let's talk about the delivery of the signed declaration. Who must receive the declaration? Again, it's got to be given to the landlord, the owner of the property where the tenant lives, or the property manager. So legally, the landlord is considered to be the owner of the property. However, sometimes tenants don't actually ever meet their landlord. They work exclusively through a property manager or a leasing office, something like that. The tenant can deliver the CDC declaration to the leasing office, the property manager, whoever has been acting on behalf of the landlord. So if you're unsure, just deliver a copy to every person who's acted on behalf of the landlord and keep a record of each person that you deliver the declaration to. And I would, if the tenant has a lease, you can check your lease if you're unsure who owns the property. It should be listed, the owner should be listed on the lease. Next steps, so say a tenant has been unable to pay rent and now they've given the declaration to their landlord. What do you do now? Continue to pay as much rent as you can when it's due. If your landlord accepts a payment, again, be sure to get a receipt or other proof of payment. Again, as I said before, it's best not to rely on the landlord to provide a receipt. It's best that a tenant take affirmative action to get their own proof of payment by using a money order or some other method that's traceable. If your landlord refuses to make a partial payment, just make a record of your attempt to pay and your landlord's response. If it's possible, try to save as much as you can to pay your rent when it becomes due. Once the CDC order expires, all that rent will be immediately due, so it's best to start saving up now. Make sure you apply for rental assistance and keep a record of where you applied. This is a good time to be applying for rental assistance. There is a lot of money out there for tenants, so I do suggest that everyone applies. Even if you checked back in January or February, there wasn't money then. There's money now, so please continue to apply. Continue to follow news reports on the legal challenge to the CDC order. Many news networks did report the order that was issued on May 5th from the DC District Court. And so I think that my hope is that those reports will continue to come through. If the CDC order is struck down, that should make the news, and so you should be able to find out there. Last, you are still required to follow all of the other terms of your lease or rules of the place where you live. So the CDC's order, again, only protects tenants from eviction because of non-payment of rent. If there's a lease violation, if your lease ends, that doesn't necessarily mean you're protected under the CDC order. So in that situation, it would be good to contact an attorney, and I will include the contact information for Georgia Legal Services at the end of the presentation. So I'm just going to go through a couple slides to go through the timeline for various situations that tenants may find themselves in. The first one is if no legal action has been filed yet, the tenant should again give the declaration to their landlord, complete it and give it to them, and then keep an eye out, because if a dispossessory affidavit, which means an eviction complaint essentially, is filed with the court and is served on the tenant, which would be done either by the sheriff handing the tenant the document or it being posted on their door, the tenant does need to file an answer within 7 days. That's extremely important. So again, don't assume that just because you gave your landlord the CDC declaration, you don't need to do anything else now. Keep an eye out for anything that's sent to you by the court. Next timeline, if a legal action has been filed based on tenant's failure to pay rent, again, complete the declaration, provide it to your landlord. Next, you are going to need to file an answer with the court stating that you delivered the CDC declaration to your landlord and attach the declaration to the answer. There may be other things you will need to write on your answer. You may have other defenses to an eviction. You may have counterclaims against your landlord if they failed to repair the property and you've been living in very poor conditions for a period of time. So this is just, we know that you'll need to turn in the CDC declaration and write that on your answer, but there may be other things, and you should contact a lawyer for advice on an individual case if you think that you may have other claims. If you've already filed an answer and now you're learning that there is something called the CDC Declaration that you should fill out, again, give it to your landlord, sign it and give it to your landlord, and then bring a copy of the declaration to the court and ask that it be filed into the court case and attached to your answer. Last, bring the declaration to any hearing that's set in your court case after giving the declaration to your landlord. Some courts are still setting hearings for eviction cases. Some courts are issuing automatic stays once the judge and the clerks of court figure out that the tenant's asking for that CDC order protection. Sometimes they'll just issue a stay, but sometimes they are setting a hearing. If you don't go to your hearing, you will be evicted if there is a hearing set. Even if you've turned in the declaration, if no one's there to present your side of the story and to tell the judge there's a CDC declaration in this case, you can still be evicted. So say that you've, last timeline, say that you've already been to court and now you're listening to this and you're realizing that you should have filled out the CDC declaration and it would have protected you. So if you, for example, if you failed to file an answer and the court issued a writ of possession, which means that an order saying that you can be removed from the property and it's not been executed yet, so you're still living in the property, or if you've answered and the court ruled for the landlord and issued a writ of possession, but again, you're still living in the property, first thing you should do is contact an attorney. What the attorney will probably tell you to do is complete the declaration and turn it into your landlord, as in the other situations, and then file a motion to stay the writ of possession. Since this is a legal document, that's why I'm recommending contacting an attorney. And that should be filed, and then also it should be filed with a copy of the declaration, and the tenant should keep a copy of those documents. In case the sheriffs come to execute the writ of possession and remove the tenant from the property, you know, you should show that to the sheriffs in hopes that that will prevent them from evicting you. It's not necessarily guaranteed if the judge hasn't made a ruling on the motion that it will protect you, but it will at least give you that option. Last thing, if you go to court, you may need to show the court evidence that you meet the requirements of the declaration. You can use things like applications for rental assistance, applications for unemployment to show your income, proof of enrollment in government benefits, again to show your income, letters or notices from employers showing that you did lose your job or you've lost work hours or your pay has been reduced. You can use bank statements or tax returns to show your income. Evidence that you received a stimulus check. If your landlord is trying to allege that you didn't make any attempt to make rental payments, you can bring emails, letters, texts, recordings, anything to show that you did try to make the rental payments. And last, if you are trying to allege that the reason that you qualify for the protections of the CDC order is that you had extraordinary medical expenses, you should bring some proof of those expenses so that the judge can just verify that you are protected in case the landlord challenges you. We've had a number of tenants ask us what they can do if a landlord has violated the CDC order. There are a couple different situations in which the landlord could violate the CDC order, a couple different methods they could use to violate it. First of all, some courts in a couple counties in Georgia, not many, but a couple, I think about 2 or 3 or 4, are not honoring the CDC order and are essentially still ordering evictions despite it. In this situation, there is not a lot that the tenant can do, unfortunately. The U.S. Department of Justice is going to be the agency that's responsible for enforcing the CDC order, and how they can do that is they can file criminal actions, or they can file cases for fines against a person or organization that violates the CDC order. The Department of Justice can also work with state governments to enforce the CDC order, but we have not had any, we don't have any knowledge that that is currently going on in Georgia. The fines that the Department of Justice can issue would be up to $100,000 for a person who violates the CDC order, or a year in jail, or both. If the violation results in the death of a tenant, that can be increased to a $250,000 fine. If an organization is found to be in violation of the moratorium, they can be subject to a fine of up to $200,000 per violation, or up to $500,000 if one of the violations resulted in someone's death from COVID-19. Again, though, these are civil fines that can be issued. They are not, a tenant cannot file an action against the landlord and recover that money themselves. It would be a fine that would go to the state. If, however, a landlord violates the CDC order by locking a tenant out, this would be considered an illegal eviction under Georgia law. And in that situation, there is action that a tenant can take if a landlord illegally locked a tenant out, or cut their utilities, or took some other action to prevent them from having access to the property without a court order. Once there's a court order, unfortunately, that does cut off a tenant's right to claim illegal eviction. So just a quick review to go over what we talked about. I've got it in the form of a checklist for tenants. First thing is make sure that you've completed and signed the declaration. Make sure that every adult in the household has done this and has delivered it to the landlord, and keep a copy for your records. Again, you do not automatically get protection under the CDC moratorium. And make sure that you've notified, if there's an eviction case filed, that you've notified the courts that you've done this. If you don't notify the court isn't going to know that you've asked for protection, and you could be evicted. Make sure that you deliver the declaration to your landlord by regular mail or certified mail, hand delivery, some kind of way where you have some kind of proof that you've done it. Continue to pay as much rent as you can when it's due. Again, the CDC Declaration does not forgive rent. It does not reduce the amount of rent that you will at the end of the declaration, or I'm sorry, at the end of the orders period owe. It just means that you have some extra time to pay that money. So be prepared to pay all past due rent and fees when the CDC order expires, or you can be evicted. Next, follow news updates on the legal challenge to the CDC order so you are not caught off guard. Again, this is proceeding in a way, it's proceeding very quickly through the courts at this point. There should be an update as early as May 18th or 19th. There may be an update from the court, as long as the court issues on whether the stay that's currently in place that keeps the CDC order in place will be continued, or whether the CDC order will stop being effective. So again, please keep an eye on the news. In the next week, we should have more information. And last, follow up immediately on any court paperwork that you receive. Again, the timelines are very short under Georgia law for eviction cases. You don't have 30 days to answer. You have 7 days once you're served with the case. If you file an answer outside the 7 days, it's too late. So again, please make sure that you follow up quickly with the court. Please make sure you do not miss your court hearing. Unless the clerk of court tells you that you don't have to go to the hearing, you need to be there. And if you're not there, you could be evicted. Okay, so that's all I'm going to cover today. The last slide here, I just have the contact information for my agency. 1-833-457-7529 is the number for Georgia Legal Services. If you do have other questions, if you have questions about a specific situation, the information that I've just provided is just general. So if you have questions about your situation, it would be best to consult an attorney by calling our number. So I hope that this presentation has been helpful, and please again reach out to my agency if you have any other questions.